Welcome back to Balancing Acts, where we're talking with Bobby Klink about protecting your online business or your service business from legal risks and exposure using software tools and resources. Hi, Bobby. So, how do you approach risk taking in your business? And what insights can you share with myself and the audience and those of us who are not attorneys?
Yeah. So what I would say is that there's a couple different ways that we can talk about or think about risk. So some of them are the legal risk, and maybe I'm more willing on to push the limits on some things than others. But when I say push the limits, let me be clear. I don't push the limits on things that are illegal. And
Mhm.
what I mean by that is marketing and advertising law. A lot of what's happening online and the way that people are presenting things is not legal. You're not allowed to make claims about results you get for people if you don't have evidence to back that up. And I just don't do that. Separately, I don't push the envelope when it comes to other people's IP. And an example of this, these are some small things. Other people choose this differently. You'll never see me use a meme or a GIF that I find somewhere else in my marketing. The reason why is there are copyright issues there. A lot of people do it. I'm just not going to do it. I don't think it's worth the risk because I can have the same impact elsewhere. And by the way, I love GIFs. So personally on social media, you'll see me using them all the time. But from a business perspective, there's some real copyright issues if you're using GIFs or memes or anything else. So I stay away from those things. But what I like to tell people is there are things that are definitely best practices that you should do in terms of maybe getting a trademark for all these different things. I make decisions all the time about, I'm not going to worry about that trademark, about getting a trademark for XYZ, because what's the worst that can happen if I don't get the trademark? I'm very careful to not step on other people's toes, but I recognize that realistically, a lot of the stuff that we could do to affirmatively protect our IP only matters in contexts that are so unreasonable to even think about ever coming up that I'm not going to worry about it. And so I take those risks and I make those decisions, but it's more of that triage. It's more of, what do I have the time? What do I have the energy? What do I have the money to spend on these things? But one of the things I do pretty religiously is get agreements, because you can always get an agreement with someone. And by agreements, I mean written agreements. Getting things in writing is the simplest, easiest thing you can do. That's why I started my business really with that, of getting the templates, because I've just seen way too many people have really bad things happen to them that could have been avoided with a simple written agreement. And so that's a place I don't skim. Now, other places, I'll tell you, you as an accountant, I'm sure there are places that you have to make decisions. And I work with my accounting team and my CPAs to figure out, where am I willing to push the line a little bit on things that I don't say they're not illegal, but it's like, hey, maybe, if the IRS comes and looks at me, they may rule for me, they may rule against me. Those are things we have to decide and think about those things. And we will make those decisions. Obviously, never do anything, like I said, I always report 100% of the revenue I get, 100% of the income. But, there are those decisions you have to make in everything you do. And I'm willing to push the line on some, but it's really kind of a gut feel more than anything else.
Yeah, and those are, sometimes there are gray areas, and you could win or lose depending on the position, the government, or your opponent on the other side of an agreement. I want to expand a little bit about what you said about the marketing, because this is coming up in every workshop that I teach. People are doing online coaching, their online courses, sales pages, lead pages. Here's an offer. Here, I'm going to do it. I did a discovery session myself. I offered recently before I did the legal audit. So tell us a little more about marketing promises. I know you had a 1 hour workshop on that, which I took so many notes. If you could just give us a couple things on that topic, I think it pertains to many in the audience.
Yeah. So this is an area. So you have the Federal Trade Commission, the FTC at the federal level, but also state attorneys general. As a general rule, there are rules at every level against what could be considered deceptive advertising or deceptive trade practices. And the easiest way to think about it is at the FTC level has set out these rules. If you're making a claim about the results that your clients are likely to get, Okay. So it could be making money, it could be saving money, it could be any of those things. If you're making a claim about results, you have to have substantiation to prove that the promise you're making is what the typical person will get. In other words, it's a reasonable expectation that a typical user will get from your services. And nobody is doing that online. Everybody is always cherry picking the best results. And separately, what a lot of people will tell you is, but I don't know what the typical results are. Well, under the law, if you don't know and cannot prove what the typical results are, you're not allowed to make a claim about results. And that is something a lot of people don't like. And there's a further thing I'm going to tell you that you're really not going to like, which is this isn't just you promising things. If you use testimonials that include results that those people got, that is considered by the FTC a representation about what a reasonable person can expect to get in terms of results from your product. And if you don't have data to show that that's typical, you're not allowed to use it except for some caveats. And you might be saying, oh, yeah, but I just have to say results not typical. That's not good enough. If you're using a testimonial that is not typical, you're required to, number one, disclose that it's not typical. And number two, disclose what the typical results are. And the way I explain this to people is you've seen this all the time in ads for diet products. You'll have these great testimonials, but it'll say the typical user will lose 8 pounds in 45 weeks or whatever the typical results are. They have the data to back that up. And this is the area that is, I would say, being violated the most online, and it creates some exposure. Now, I'm not going to try to scare you and make you believe that if you're a small time, if you're a relatively small business, that the Federal Trade Commission is going to come after you. But they are increasing compliance issues here. State attorney generals are starting to go after these issues. So it is something you should be thinking about. You should not be making those kinds of claims if you don't have data and evidence to support that that is what most people or the typical person is getting from your program or your product or service.
Talk about subjectivity and proof. With taxes, I know, okay, you have a receipt, there's the proof. But this is very, very subjective. But I would advise business owners as listening, do you put this on your radar and on your list for working it out and deciding what exposure works and how you can improve on that, or add results not typical to everything. I don't know.
And if I could, Leno, I mean, one thing I'll say is like, your testimonials don't have to be about results. You could have testimonials about how amazing you are to work with, about how you make things simple and easy to understand, for example, if that's relevant, how you and your team are ultra responsive. And quite honestly, in today's day and age, I mean, yes, the results can be what lure people in, but quite honestly, the results that lure people in are generally the types of things that are so overblown that you can't justify them. Now, and there is a caveat. If you will make a guarantee and say, if you do not get these results, I will give you a refund, that's fine. You can make that claim, but you just have to be honest with people. But like I said, luckily with me, my good result is I use Bobby's products and nothing happened. I mean, that's kind of a good result for my clients. So I've never had this. I've never been able to use these wonderful results-based testimonials. So, I mean, maybe it's kind of me, I can kind of talk about it and say, well, don't use them. And I get that they're powerful marketing, but I would stress to people that you should be careful. And I think a lot of people are starting to see through those types of claims too.
Yeah, I like how you just shared that your testimonial doesn't have to be results, but more about working with you and what they learned, maybe working with you. And I think that might be an easier path for some of us. And some business owners are, they're good at sales. That's kind of their skill. So they're going to push the envelope on some of the claims and things they make. And then there are others, knowledge workers, professionals, consultants who are going to be a little more conservative about the statements and promises they make. So thank you for sharing that very insightful advice. What legal trends are you most excited about or concerned about as they impact small businesses?
Yeah, I mean, I think the legal stuff that is really I've been thinking a lot about lately is tied up with AI, and there's a lot of sticky, ugly issues there, and some of them are some of them that are resolved. I don't want to say I don't like the way they're resolved. One of them that a lot of people don't realize is it is very clear right now. Courts have decided, and the Copyright Office have decided that if you use AI to create something, it is not protected by copyright. If generative AI creates an image, it is not protected. Now, that doesn't mean you don't have the right to use it. It means that anyone else could just copy it from you and use it too. And it seems to me, and I would say it's hard to say exactly because things have changed so quickly. At the beginning of last year, if you wanted to get good images from AI, you really had to do a lot of prompting. Nowadays, you don't. But that may evolve, that may change, but I do see a lot of issues coming up there and people taking other people's copy and using it. And quite honestly, I don't understand how any of these AI generation engines are not guilty of copyright infringement, not for reproducing it, but literally taking the data and making a copy of it to ingest and train their model. That is copying copyrighted work. And so there's a lot of interesting issues that are going to come up there. And I'm glad I'm kind of on the sideline. I'm not litigating this stuff, not looking at it, but it is very interesting. And I think there are going to be things we're going to have to think about and understand as business owners about it moving forward.
Thank you for that. And that, you can't do anything now without talking about AI. I learned so much from talking to you, as I do every time I listen to one of your sessions. So thank you for joining us. Thank you for giving us ideas about how to handle our marketing, sharing your legal audit. I hope people will check that out. How can people find you?
The best way is just plainlylegal.com. I'm not that active on the socials because I prefer to do other things. But if you go to plainlylegal.com, that's always the best way to get in our world, get the free kind of guidance, and then go from there.
Thank you very much. Again, fascinating conversation. I hope you'll join us for our next episode of Balancing Acts, where we'll bring you another very insightful guest and expert to share practical tips and strategies.
This has been a Now Media Networks feature presentation. All rights reserved.